Okay, so that's the court system. That's a very little bit on the constitutional system in the sense of the sovereignty and the supremacy of Parliament. Let's get into the fun stuff, though. When is a case sufficiently like another case that it should be a precedent? Okay. Let's say you go to the cafe after this lecture, cafe next door in the Bloomsbury building, and you order a bottle of, oh, let's say ginger beer. I've actually never had ginger beer, but apparently it's an English delicacy, a treat. A lot of people in England love ginger beer. You may or may not know that ginger beer comes in an opaque bottle, a colored bottle that you cannot see through. So you're sitting there with one of your classmates and you're drinking your ginger beer, and your classmate is having tea or coffee or something, and you notice at the end of at the bottom of the bottle, when you pour the last bit of the ginger beer into the glass, what do you find at the bottom of the bottle? No, even worse. The decomposed remains of a snail, let's say. Ew, you say. You immediately get grossed out, you hold your stomach, you roll on the floor, prostrated in disgust and agony, and you say, I have suffered some damage here, either emotionally or physically. I would like to recover some damages, some money for the harm that I've suffered from drinking this tainted bottle of ginger beer. You don't know whether or not there's a precedent for successfully suing somebody who has sold somebody else a tainted bottle of ginger beer. So you do all your research, you look through all the cases, and the only case, am I walking too much? Are you having difficulty following me? Sorry. And the only precedent you can find is a precedent where, let's say, somebody sold a toy car that was defective. And when the child got the toy car home, the toy car caused that child some damage because there was a short in the electricity or something. Don't worry, the child wasn't badly hurt, just frightened and a little burn. There's a case. Is that sufficiently like the decomposed remains of a snail in a bottle of ginger beer? Let's say there's another case that was decided before. Well, let's first deal with this one. Who wants to argue in favor of the claimant, the person who wants the damages? And the only argument you have, or the only precedent you have to rely on, is the defective toy car. Who wants to say that that's sufficiently like the ginger beer case that it ought to be a persuasive precedent? Come on, somebody be a creative lawyer. Make that argument. Yeah, make it loud so that everybody can hear. Go for it.
But I don't see why it would be a precedent. Yeah, I think that's pretty much the same case.
It's pretty much the same case.
I mean, they bought something that in the end they couldn't know that it was damaged or...
They're both something that the ultimate purchaser couldn't, they both were flaws that the ultimate purchaser couldn't see. They were not visible to the ultimate purchaser. Is that one of the things you're saying? And in that case, that's what makes them sufficiently alike. Okay. Anybody else have any other arguments for why they might be sufficiently alike?
Maybe the person who produced it is not enough careful.
The person who produced it way back at the beginning in the manufacture didn't take sufficient care. So why should the ultimate purchaser have a claim against? Why shouldn't the the cafe who bought the drink from the manufacturer, or John Lewis who bought the toy from the manufacturer have a claim? Why should the ultimate consumer have a claim? Surely that's too many steps, isn't it? Yeah. You need to shout.
It's so unlogical, I mean.
It's, yeah.
Yes. Why you don't have standards for beer?
Oh, no, 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 no. Well, this is a make-believe case. We do have standards. Absolutely, we do have standards. Let's pretend there's no consumer protection laws and there's no safety standards or nothing like that. Let's just pretend we're operating without that. But you're right, we do. Let's just think about it in terms of legal reasoning right now. Okay? Okay, somebody make the case to protect the ginger beer manufacturer and say, whoa, I can't be expected to be responsible for that person's oversensitive stomach. Anybody want to make a case in defense of the ginger beer manufacturer? Why that case is not sufficiently like this case?
I think that both of them got injured and they can ask for compensation, mentally or physically. Yeah.
Oh, you're acting for the claimant. You don't want to defend the manufacturer. Oh, okay. Does nobody want to defend the manufacturer and say, that's not a precedent? It's completely different. It's not sufficiently like this case at all. And so, my lord, you should disregard that case. Anybody want to make that argument? And if so, tell me the reason why you think it should be disregarded. Yeah.
Because I would say that I, as a company, the bottling company, I would have had sufficient care bottling the liquid to say that I wasn't really aware of this at the moment because I did took the care that I needed to be a bottling company.
Okay, well that's a good argument on the facts that you have in front of you, but it doesn't really rely on why the precedent with the toy should not be applied.
Because they're different kind of business. So
Different product entirely?
So the type of awareness that the toy company should have is completely different to mine.
They have a higher standard. They ought to exercise a higher standard of care. Why?
Product is for children. Mine.
That's an important factual difference. The toy company was found liable in the previous case, my lord, because their products were directed towards children. And of course manufacturers who manufacture products directed towards children should be held to a higher standard of care than people who manufacture products like people like me, who manufacture products that are meant to go to the adult public. I shouldn't be held to the same standard. In other words, the facts are sufficiently different so that that previously decided case is not a precedent for this one. Anybody, any other arguments you might want to make? Yeah?
Another problem would be related, for example, between the drink and the toy, because for the drink, the problem would be related to the seller that maybe didn't take care about the drink.
Okay.
In a place where the drink would be made.
Okay. Maybe we ought to be...
Because more direct to how
Okay.
which way the toy will be damaged.
Okay. So let's make our argument, let's pretend we're in court. Well, my lord, toys come packaged in boxes, and we can't expect John Lewis, the seller of the toy, the person, the business that sells it to the ultimate consumer, we can't expect them to open every box and check it. Ginger beer comes in a way that the seller, the shop, should be able to notice. We should be putting some responsibility on the ginger beer seller, not manufacturer, seller, to have some care here. Whereas we shouldn't expect that of the toy seller. That's another interesting, potentially important factual difference. The whole process is all about deciding whether the case that you've got in the past is sufficiently like the case you've got that you're arguing now that you want it to be used as a precedent, or you don't. It really depends on what side of the argument you're on. If you're acting for the claimant, if you're acting for me, whose stomach was hurt and who was emotionally distraught as a result of seeing this snail, then you want to say that that toy case is a precedent and it ought to be applied, and here's why. If you're acting for the ginger beer manufacturer, you want to say, that case is nothing like this case. It shouldn't be applied as a precedent, and here's why. Judges do that all the time in their decisions. What they get is lawyers standing in front of them making arguments about why this case should be applied and this case shouldn't be applied. And then the judge, in his or her wisdom, decides which arguments they prefer, which cases they think should or shouldn't be applied. They give reasons why the case should, previously decided case should or shouldn't be applied, and they make their decision on your case. So you will be able to read the judge's reasons why that toy case either should or should not be a precedent for the ginger beer case. That's common law reasoning. That's what every law student starts to learn on day one of legal education, and what they continue to learn throughout their entire career as a lawyer and as a judge if they get appointed to the bench. Because that kind of common law legal reasoning is not a skill that you either have or you don't have. It's a skill you develop, and you learn to make creative arguments about why the precedent should or should not be applied in this case. That's how the law gets changed. It relies on creative lawyers making interesting arguments, which is exactly what happened in 1932 in the case of Donahue against Stevenson, which is the snail in the ginger beer case. In 1932, there was no such thing in English law as the tort. Tort is a wrong that's committed by one person against another person. There was no such thing as the tort of negligence. You could not sue someone to find them negligent and that their negligence caused you harm. Didn't exist in English law. And then along goes Mrs. Donahue to the cafe, orders a bottle of ginger beer, finds the decomposed snail, and she sued the ginger beer manufacturer in 1932. And you know what the court said? It said, Mrs. Donahue, you have sued the wrong person. The only action you have, potential legal action you have, is an action for breach of contract. And your contract was with the cafe. The cafe had a contract with the manufacturer. You didn't have a contract with the manufacturer. You've got no action. Mrs. Donahue said, there's something wrong here. Surely the manufacturer owes me some duty of care. They don't only owe duties to those who they have contracts with. Surely. Well, it went all the way up to the House of Lords, which was the highest court before the Supreme Court. And the House of Lords created the tort of negligence. And it said, basically, that the manufacturer does owe a duty of care to all those people that it should reasonably foresee will be affected by its actions. So you didn't any longer have to have a contract with somebody in order to have responsibility toward them. As a result, we all now have responsibilities to everybody in everything that we do. We have responsibilities to all those that we can reasonably foresee will be affected by our actions. So if we're driving negligently and we hurt someone, they will have an action because we should reasonably foresee they will be affected by our actions. Manufacturers have a duty of care not only to the people that they have a contract with, but to everybody that they reasonably can foresee will be affected by their products. And it took a creative lawyer to use cases that had nothing to do with drinks or edible products of any kind to make those kinds of arguments in the House of Lords in 1932 to create what we now know of as the tort of negligence. Now, the tort of negligence, which some of you may or may not know, has developed significantly since then, so we have different standards of care and how much care do you owe, and you owe higher standards to some and to others, and it's only people who are reasonably foreseeable, so if it, you know, there's 2 or 3 or 5 steps along the road and you couldn't foresee that the ball would bounce that many times before it hit its ultimate person, then you're not liable. But needless to say, it's all about judicial reasoning. Okay? So common law lawyers are all about looking for interesting and exciting and innovative and creative ways to either distinguish a previously decided case or argue that that previously decided case should be a precedent and apply. You get the sense as well from this description of how law, judge-made law is made, that a lot depends on the lawyers and their ability to construct and present arguments, which is true. I mean, this is perhaps either an advantage or a disadvantage of the system. One side has a really clever, really good lawyer and the other side doesn't. That could change the law. You have to sort of assume that the lawyers are equally matched. Okay. Any questions? Yeah.
I have a question. What about we have a precedent that previously court decided about this situation, and this another similar case happened after might be 10 years, but in that case, for example, if I say the previous example, the manufacturer were fined by court, but in the last case, the lawyer who protected the manufacturers, I mean the rights, was not so creative, but other side was creative, and actually that another side showed more sufficient, more similar cases. How should, in this case, court judge will decide?
Well, see, that's the other thing about the common law system. That there was an example given here. If we have a series of cases, maybe some with a not so good lawyer and another series of cases, how can we know how the judge will decide? Well, you can never know how the judge will decide. Actually, that's true. Legal reasoning is not a science. It's an art. One can never predict with 100% certainty how a judge will interpret those cases or how a judge will interpret counsel's argument. When we teach undergraduate law students, we give them on their examinations fact situations, like the one I just gave you. And we say, advise Mrs. So-and-so. We expect them to know the cases that were decided before and give us a reasonable assessment of how they think the judge will interpret those cases. It's an examination to know that they know the law, and it's also an examination to test their judgment. But it's a foolish student and an even more foolish lawyer who will ever say to his or her client, this is 100% winner. You just never know.
In this example, the judge will be more corrupt because we have 2 cases.
We have to, no.
They're equal.
The judge, all judicial decisions in the English legal system, you have to have reasons. So the judge will always have to give reasons for his or her decision. And if the reasons are just completely wacky and make no sense, then the Court of Appeal will hear it and fix it. So the judge can't just make a decision and say yes or no. They have to give reasons. That's what the common law system is all about, because it's their reasons that are as important as their decision. The reasons actually are more important than their ultimate decision.
The judge will always have reasons.
Every judge will have reasons, and every judge, if they know how to be a good judge, will be able to find a way to frame their reasons in a way that looks plausible, if not correct. Because nobody knows if it's correct until it gets all the way up to the Supreme Court and the Supreme Court says, yes, it's correct. Up until then, you can just keep appealing and have the court higher say, no, you were wrong. But until you get to the Supreme Court, nobody knows if it's correct or not. If nobody appeals, then you have to assume it's correct, because nobody's bothered to appeal. Now, as a result of Donohue and Stevenson, of course, we have a lot of legislation now protecting, and that's your question. We have a lot of legislation now protecting consumers. We have a lot of legislation creating standards for manufacturers. But all of this came from the Donohue and Stevenson case. So you wouldn't ever really have to actually sue now. Well, you could. But it would be found that the manufacturer violated one of the statutes and all of that. But at the time, there weren't any.